Well, welcome everybody to the 3PB ToLATA lecture. Thank you for taking time out of your busy Christmas schedules, not just your family schedules, but I think we all recognize as professionals how time seems to run very quick just before Christmas, and you've given us the benefit of an hour of your time. So thank you. My name is Hamish Dunlop. I am a barrister at 3PB. I'm head of the Family Finance Group, and it gives me great pleasure to introduce you to our seminar this morning and to my co-speakers. I'm going to give you the speakers in the order in which you're going to be hearing from them this morning. First of all, Rachel Bale, one of our specialist juniors in the property chancery and matrimonial finances, and she has a particular emphasis in her practice on trusts. She is, I know, reputed to be a fierce and trusted advocate, and she often appears in cases well beyond her year of call. She has a fairly broad practice. She advises and represents in multidisciplinary matters, property, trusts of land, chancery, trust, probate, and financial remedies. And she's going to open the seminar for us. She's going to talk for about 25 minutes on the practitioner's guide to trusts of land. So we're going to get stuck into some of the substantive law, I hope. You're then going to hear from me for a short talk on essentially procedure, the relationship between trusts of land cases and the financial remedy arena. And then we're going to conclude by hearing from Louise Worton. Louise is deputy head of our property and estates group. As a money specialist, she deals with all aspects of family finance, including provision on divorce, of course, but also trusts of land application Schedule 1. She's an accredited mediation advocate, and she's ranked in all the directories, of course. She's going to talk to us about Schedule 1. Just before I turn to our speakers, and in particular to Rachel, a couple of ground rules. First of all, we aim to take some questions at the end of the seminar, which should start about 12 o'clock. We'll take questions for about 15 minutes. Please, therefore, do put questions into the Q&A box, which you'll see at the bottom of your screen. And we very much hope that following the seminar, we'll be distributing the presentations. They'll be emailed, the PowerPoint texts, to all of our attendees after the event. Well, that's all from me for the time being. I'm delighted to hand over to Rachel. So thank you very much. Rachel Bale.
Thank you very much, Hamish. I will just begin sharing my slides now. Okay, so welcome everybody. This will be the practitioner's guide to ToLATA. To start with, I'll give a brief agenda. I have the unenviable task of trying to run through as quickly as possible the substantive law in ToLATA, which is both fascinating but also quite comprehensive. So we will be going through some ToLATA concepts and the application to both domestic and commercial context as well. I will also then be briefly touching on procedure, touching on those CPR rules, which are extremely important in ToLATA matters, and including talks on subject matter on ADR, mediation and other forms of ADR as well. And at the end, I will briefly touch on cost implications. So, why is ToLATA important? I think this is something that's sometimes often overlooked. There is a real growing trend, as we know, societally, of unmarried couples in the UK. And I've put a statistic up there of around 1.5 million in 1996 to over 3.6 million in 2021, almost certainly increased since that point as well. So that's an increase of 144%. On average, people are choosing not to get married rather than married. So there is no comprehensive legislation for cohabiting couples in the UK, which is why ToLATA is such an interesting and fascinating area, largely led by precedents. There's a real blend, we say, from property, trusts and potentially family aspects as well, which also makes it quite interesting. And another point of ToLATA as well, which people find quite unusual, is where it begins. So often you'll find a ToLATA case that begins from a possession proceedings, for example. It may start off as a simple possession claim that then turns into a ToLATA type matter. Or you may see it perhaps in private children matters that then turn into ToLATA matters when we're dealing with property and assets. So it pops up in all different ranges and all different contexts. In terms of what actually is ToLATA, of course, we are centred around the Trusts of Land and Appointments of Trustees Act 1996. The real thrust of ToLATA is it deals with issues and assets from the ownership of land by those who are not married, and that can include, of course, cohabiting couples, family members, and also commercial relationships, commercial partnerships that break down when the central point is property. Of course, there's also parts of ToLATA which deal with the rights and obligations of trustees, and I've given the definition there as an individual or a company that is appointed to carry out the purposes of a trust. So a lot in this piece of legislation and a lot of different ways that it can interface with other rights. Louise will be talking about Schedule 1 shortly, which is of course relating to the provision of children, so I won't be dealing with that in this talk. In terms of commercial matters, something we've had a few questions on, ToLATA can prop up in situations where there are investment properties, potentially where rental income is being derived, even if between family members. Secured creditors, lenders, mortgagers, banks looking to secure their interest on a property, and as mentioned, business partners as well. Of course, there is a large overlap with insolvency matters often in ToLATA, which is outside the scope of this talk because it is in itself an entire different area, but just to set out, the context does matter in ToLATA, and it will be treated differently by the courts depending on the situation, especially when we're looking at domestic versus commercial cases. What are the most likely applications? So you're most likely to go to court, or the applications we see the most, are determining beneficial interest within a property. So this is often where parties are disputing as to whether they're 50-50 or 60-40 or different arguments as to why they are deserving of more equity in a property. Second to that, I would say, is orders for sale. Again, very, very common, and that can happen in many different contexts, perhaps in commercial property, farmland, or as I say, the family home. I've put the case of Begum and Hafiz, it says 2015 Court of Appeal case. I'm finding myself personally drafting this a lot recently and advising on this case quite a lot, because there is a common misconception that the courts have the power to direct one co-trustee to sell their share directly to the other co-trustee, and actually there is no power in the ToLATA Act to do that. What they can do, and what the Court of Appeal have done as a workaround to this in Begum and Hafiz, is to put the property up for sale with the first right of purchase going to the co-trustee. And the beauty of this is that the courts can actually set the price at whatever they determine. It doesn't have to be the market value of the property. So that is a workaround for the courts to basically allow party B to purchase party A's interest without directly ordering it. And it is quite an important case that I'm finding myself, as I say, putting in pleadings right at the outset. Equitable accounting, I will go through that shortly in terms of the checks and balances that often take place at the end of a ToLATA hearing. And also, again, just to show how ToLATA interlinks many different concepts, it often raises ideas of proprietary estoppel, protecting your promises, undue influence in terms of pressure into entering into transactions, and potentially fraud as well if one party is suggesting that they haven't signed something or haven't executed something that's been presented to the courts. So a real fascinating area, as I keep mentioning. So some key reference points. There's a roundup of cases here which are pertinent, I would say, to ToLATA. Oxley and Hitchcock, Stack and Down is your go-to Bible precedent, I would say, seminal precedent that really sets out the court's approach at this stage to cohabiting couples, and particularly looking at this idea of indirect contributions as opposed to just purely financial direct contributions to a property. Jones and Kernot, again, really helpful in terms of when we're looking at modifying agreements and if things have changed. And Goodman and Gallant, which I'll go through, really talking about when things are in writing, how conclusive is the effect. So really important cases that I would urge practitioners to have a look at when starting in this area. Okay, so substantive law, types of trust. So express trust is your main starting point. That's the holy grail of what you're really looking for, I suppose, as a practitioner. Obviously, when it comes to property, there are two ways that you can hold property in terms of the beneficial interest. Either as joint tenants, which has the right of survivorship. So if party A dies, 100% automatically passes over to party B, or of course tenants in common. And I'm sorry if I'm teaching people to suck eggs here, but it is important to go through the basic principles. Tenants in common is where parties can declare that they are holding property either 50-50 in divisible shares or potentially in unequal shares, whatever way they see fit. An express trust is basically a written document which sets out what the parties intended, normally at the time of purchasing the property. And as of 1998, there is what's known as the TR1 form when you're looking at transferring property, which provides at box J01 an express declaration of trust where you can expressly say there's two of us owning this property and this is how we would like to hold it. Once that is signed and once that properly signed, properly executed, it is difficult to move away from that. Now, of course, there are examples where we can, and this is the whole point of this area of law, and we'll go into it. But the conclusive effect of an express declaration of trust is really important. And it all comes back to this philosophical principle that equity follows the law. Whatever you've put in writing as your registered legal interest, equity should follow, or that's the starting point at least. Goodman and Gallant, as I mentioned, is a really core case which talks about the conclusive effect of an express trust and basically sets out that it's only through rectifying or through rescission of that, through potentially fraud or undue influence, that would actually render that void. Interestingly, well, I'll come on to that point in a second. Resulting trust. So again, this is a slightly different trust system. What it means is it returns the beneficial ownership in the trust property back to the settlor. What that actually means is we're really focusing on purely the capital contributions that parties have put into the asset, and the seminal case there is Lloyds and Rossett Bank. Now, the point of this cases, this is normally used for commercial transactions and won't be used, and it is specifically, as Stack and Dowden set out, not to be used in domestic contexts where we're looking at two loving partners or cohabiting partners in a familial relationship where the purpose of the trust is actually quite different. If we're looking at two business partners putting money into a company, of course, that's a little bit more arm's length, and we can be looking at purely what they've put in. The share in that case will be calculated as a percentage of the purchase price of the property, and then working out when the property is sold what the divisible share should be there. Constructive trust I will go into, so park that for a second. And then, of course, estoppel claims, which I briefly mentioned. Estoppel is all about protecting promises, really. If A promises something to B and B relies on that promise to their detriment, and this idea of detrimental reliance is important, then A should be stopped from going back and basically reneging on their promise. A very simple concept that pops up, I think, in a lot of different areas. So let's move to the constructive trust, because that is the heart of most ToLATA claims. Can an express trust be modified? So Jones and Kernot is a really good example here of where there was a family home in the joint names of both parties, both responsible for the mortgage, but for whatever reason they had not signed an express declaration of how they wanted to buy that property. They hadn't put joint tenants and they hadn't said tenants in common. So at this point, they were registered proprietors, both of them, so it was presumed that it was 50-50. However, the presumption may be displaced by a different common intention expressed when the home was purchased or at a later stage. If that is not found in terms of any express documentation, a common intention may be inferred from their conduct. And then finally, where there is no evidence of common intention at the outset, each is entitled to a share as the court thinks fit, having regard to the whole course of dealings. Jones kind of really makes very clear that each case turns on its facts, so it will be very, very highly dependent on the factual sensitivities of the case, whether there were children, what the contributions were, what the conversations were at the time, how the parties potentially held their finances, were they joint bank accounts or separate, which again we saw in Stack and Dowden as well, to really set out the ways and areas where it may subsequent conversations perhaps may change or modify the trust at the beginning. Let me be clear on what we're talking about. There has to be clear agreement. So the pinnacle of what you're looking for are clear discussions, clear maybe letters or emails or text messages even, which clearly state we don't want to hold this 50-50. In actual fact, you get 80% and I get 20%, as an example. Of course, that's not always available, and actually quite rare that's available. So often it comes down to oral discussions. One party says that they've had this conversation, the other party can't remember it, and that has to be tested at court. And then we move to stage 3. If we can't do that, what is the conduct? How did both parties act? I want to just pause. There's another case that recently came up from the High Court, which is Thomas and Seinberg, by James Pickering Casey, who was sitting as a deputy High Court judge. And actually involved one of our colleagues from 3PB, Mr. Ingham, as well. And in this case, it's set out, and it's only a High Court precedent, but it's set out 3 stages, really. 1, an express declaration of trust will be conclusive unless it can be rectified. That's following Goodman and Gallant. However, it therefore follows that an express declaration of trust is not capable of being overridden by a common intention constructive trust, which arises either prior to that express document or at the same time as that express document, because the express document must take effect, that must be conclusive. Point 3, however, that if there is an express declaration of trust, it can be capable of being overridden by a subsequent agreement. And that's the key point from Seinberg. And I really think kind of the elasticity of the courts at the moment and what they're trying to suggest is we're not just looking at if things are in writing versus things orally, we're looking at timing. So if there is a clear agreement that can be seen from documentation or potentially inferred later down the road, and that's probably going to be very important for couples that have been together 15, 20 years, who have quite different lives or quite different conduct when they first bought the property, that is what will be looked at, the subsequent agreement. So quite an important case there, Seinberg and Seinberg. Again, constructive trust, I will leave this on the slides, you'll have this circulated around. It just breaks down a little bit more what we're looking for in terms of the intention, written agreement, discussions, and then looking at conduct. When we're looking at direct and indirect, I should mention what we mean by that. Direct, obviously, is referring to capital contributions to a property, mortgage payments, perhaps renovations that actually increase the value of a property. Indirect is deliberately left wide, but can include things such as childcare and other familial, I would say, contributions to the family. Okay, quantification is the same thing. Essentially, was there an agreement? And then if there was an agreement, was there a discussion about how much it should be divided by? Then we look into detrimental reliance. Now, I'm not going to spend any time on this. I've deliberately left the slides quite comprehensive so you can go through in your own time. But Hudson and Hathaway is a really important Court of Appeal case in 2022, which really focuses on the idea of detrimental reliance. And the point to take away from this case is detrimental reliance, it's point 2 there. It remains a key component in establishing a common intention constructive trust. It's not enough for one party just to simply say, oh, there was an agreement, we decided this back in 1995. How did party B rely on that agreement? What did they do? Did they give up something? Did they continue paying something in relation to the agreement? How did that conduct change after that subsequent agreement? Quite an important point to take away. I'm going to go through very briefly. So what are we looking at, in which sections of ToLATA are important really? Section 14 is where you're looking at the powers of the court. So who can bring an application? It's a trustee or someone who has an interest in the property. Now this is important because section 18 of ToLATA clearly states that this section 14 does not apply to personal representatives. If someone dies and you step in their shoes as the personal representative, you do not automatically get to ask for an order for sale. You must either be a trustee of the property or have an interest in that property, potentially as a beneficiary. So just something to bear in mind there, because that's often overlooked when drafting. Section 15, quite important, sets out the factors that the court will weigh up if ordering a sale or making an application under ToLATA. The point I really want to look at here is point C, the welfare of any minor who occupies or might reasonably be expected to occupy. Here we're looking at children. Now, again, common misconception that if you have children under 18, automatically they can remain in the property. That is not what ToLATA is stating. It is not the same as potentially the weighting of a Marriage Causes Act 1973 that we see in financial remedies, but it is a factor the courts will weigh. And where I've seen them to be quite successful, these arguments are whether children are particularly young or have particular needs, for example, some special needs that mean they require a slightly bigger property or a slightly adapted property. This can be quite a successful argument in what the courts will weigh up as to whether an order for sale should be made or not. Ultimately, though, it is just a weighing exercise and will not be determinative of any application. Okay, equitable accounting. So very briefly here, because as I do want to move on to procedure. This is what tends to happen at the end of ToLATA matters, where, as I say, it's a checks and balances exercise. What we're looking at, or the court will decide, is are there any unmatched contributions that one party has made that ought to be taken into account when looking at the division of net equity. And the most common are mortgage contributions, potentially renovations, actual liquid renovations to the property, or one party being in receipt of rental income and the other party not being in receipt. There is also the situation of occupational rent. If one party is ousted, forced out of the property and not allowed to return, they sometimes ought to be compensated for their lack of occupation, being a set amount, the market value rental of that amount. Often, however, that is counteracted if one party is paying the mortgage contributions. And often, if the party is not ousted out, just simply decides to leave, that will not be a successful argument. Okay, procedure. I will briefly go through procedure. So, civil procedural rules. This is the most important thing for the family practitioners listening. You must be familiar. Now, a lot of people are afraid. Your white book is your absolute go-to. It sets things out very comprehensively and the rules to follow. And once you do a case once, it becomes a lot more simple. But of course, we will always advise that you get counsel's advice early on if you're wanting to pursue quite a difficult case. Pre-action protocol, it's a standard protocol which applies to ToLATA cases. There's not a separate one for ToLATA, so that talks about negotiation and letters of claim and letters of responses and the information that's required at that stage. Once you get to evidence, there are, I would say, 3 really important things that you are looking for from your client. Number 1, you must have the TR1 form. You really want to be looking at whether there was an express declaration at the beginning. Number 2, you want to be looking at your conveyancing file, and this is often really overlooked until quite late in the game, but it should be the number 1 thing that you search. You want to see what happened at the beginning at the purchase, whether there are any conversations, whether there was any advice from the conveyancers, and what the intentions were at that stage. And then, especially if you're pursuing this idea of amending an agreement or subsequent agreements, you're looking at communications, emails, WhatsApps, letters between the parties, anything that can kind of substantiate this idea that there was a significant change of position. don't always believe your clients when they say, oh, I've got nothing, I haven't got anything. Often I get to conference, they state, oh, I don't have anything in my documents, and then I push them a little bit more to have a look. And it's quite amazing, the perhaps in heated arguments, the correspondence that comes up, which suggests an agreement with regards to dividing assets. In terms of ADR, so since the 1st of October this year, there has been a bit of a shift in CPR rules, namely CPR 1, of which the overriding objective is enshrined, enables the court to deal with cases justly, and at point F, promoting or using alternative dispute resolution. So what that is doing is the court's encouraging parties to use ADR, and it will be reflected in costs if they don't often. This is, I would also just do a plug for ADR. It's a very, very effective tool when it comes to ToLATA. I always recommend doing it as soon as possible, and if possible prior to issuing proceedings, because it's a technical area of law, and it is very fact specific. You have to weigh up your client and how you think they're going to prepare as a witness, but often as well, there's just not a lot of equity to be fighting over, and ToLATA costs are astronomical, or can be, as I'll briefly touch on. And so it is important, I would suggest, and a really good tool to try and bring people back together with a settlement. Mediation is probably your core area to go to. There are also, of course, private valuations. So you can have a private FDR type situation where you have an evaluator who sits and listens to both sides, and gives an indication, and the parties can go away and settle between them. It's definitely something to be aware of, and encourage your clients to engage in. I'm not going to go through in too much detail procedure. I know Hamish will also touch on this, just to be aware that there are two ways that you can issue a claim. Part 8 is used for the simplified procedures, where you're looking to basically front load your evidence at the beginning. You provide your witness statements, you provide your documentation, and you're hoping for a bit of a swifter resolution through the courts. Part 7 is where it's a lot more contentious. So we know there's going to be issues with regards to beneficial interest. We know there might be a proprietary estoppel claim, and we'll need detailed pleadings and witness statements and disclosure to follow. I've left some core bullet points on the slides, which you can go through in your own time, as to what exactly the procedure is, defending a claim, and the documents that need to be provided for it, for those family practitioners who may need a little bit more assistance with CPR rules. What I would say is a point to remember: there is no default judgment for ToLATA cases. You can apply for summary judgment, which basically means there are no prospects of succeeding in this case. Let's deal with it as soon as we can at an early stage and try to get rid of it. Default judgment is where a party has failed to provide their defence, and then a judgment is entered in default. That's normally only for monetary claims. It's not for when we're dealing with beneficial interests or declaratory relief. So you won't necessarily automatically, you won't get default judgment in these types of cases. But again, please be careful with your deadlines. If deadlines are missed, you will be penalised in court. There will be cost consequences, and therefore it's really important to either seek extensions from the other side or to apply for relief from sanctions. The last point that I just want to move to before I take over Hamish's time is costs. So very, very quickly, CPR rule 44.2 applies on this. There is really a two-stage process when it comes to costs. The courts will be looking at, number one, what is the principle here? Why should I award you costs or not? Normally costs follow events, so an unsuccessful party will be ordered to pay the costs of a successful party. Of course, there are lots of different arguments, especially in ToLATA cases, and it may be that you're successful on one point but not on another, and that could dissuade a judge or persuade a judge to provide maybe limited costs. Stage 2 is the amount, so that will be provided in an N260 form of all incurred time and costs incurred in terms of disbursements, and then the judge will go through, normally on a summary assessment, work out what's fair and proportionate. However, if conduct has been so bad that the courts deem that a punishment is needed, really, indemnity costs can be awarded, in which you'll get probably 70 to 80% of all your costs back. Applications, there might be many different applications in ToLATA cases. The normal rule is cost in the case, but you can always argue the toss, and you can always suggest that actually we shouldn't have had to come to court for this relief from sanctions and I should get my costs for it. And I would just urge for consideration of Part 36 and colder bank offers. It's really, really important to try and minimise your costs and be quite tactical using Part 36s in ToLATA cases. I think that is my allocated time, so I will hand over to Hamish. Sorry, Hamish, and thank you very much for listening.
That's great. Thank you so much, Rachel. I'm just going to get my slides up on screen now, and hopefully should be sharing. The next 10 minutes, we're going to be considering trust of land applications specifically in the context of the family court. And I hope I'm not being disloyal to my financial remedy practitioners if I break a secret that I think most family lawyers have a pathological fear of trust of land cases. When faced with a trust of land action, most family lawyers say, well, frankly, I would rather be blindfolded with a red blindfold and set off into the unknown than to have to deal with a trust of land case. And it's often a fear, of course, of the substantive law, the vagaries of the 1925 Law Property Act, constructive resulting trusts. But Rachel's lecture has cleared quite a number of those doubts for us. The other fear, it seems to me, that confronts family lawyers is the procedure. Faced with a trust of land case, family lawyers say, my goodness, I'm standing in front of the dark forests of the Civil Procedural Rules. Am I going to have to make my way through the complex and Byzantine paths in that forest, or am I going to be able to run this case through my user-friendly and much more familiar FPR? Well, it's going to be that second issue that we're going to be spending the next 10 minutes or so considering now. That's the procedures for bringing cases that involve investigations into legal and beneficial interest in property, those investigations and how they interface with family law cases. We're going to be looking at the family court's jurisdiction to investigate legal and beneficial interest. We're going to look at the principles that the court must apply when it does so. We're going to look at the procedure to join a party to a financial remedy case. And we're going to touch finally on procedures after you've joined that party to a financial remedy case. Well, as Julie Andrews said in Sound of Music, let's start at the beginning because it's a very good place to start. Jurisdiction. It's worth breaking down the two principal types of investigation into legal and beneficial interests that a family lawyer is likely to have to take on. The first is what I'm going to call a sort of pure trust of land case. That is most commonly, of course, a cohabiting couple, one who's broken up, their relationship is over, and they have fallen out with their former partner as to the ownership of the home that they lived in. So, as I say, a sort of pure ToLATA case. The second context in which investigations into legal and beneficial interests form part of the family court's work is in deciding what assets belong to the parties in the course of the computation exercise in a financial remedy case. That the fact-finding stage, the first stage in any analysis of a financial remedy case. Those two different arenas in which the investigation is being carried out have very different rules so far as the family court's concerned. Let's look at the first, what I call the pure ToLATA case. Well, the red traffic light on our screen shows us the simple point that the family court does not have jurisdiction to try what you might call pure ToLATA cases. The family court is, of course, a creature of statute created in 2013 by amendments to the Matrimonial and Family Proceedings Act of 1984. And the family court is given a number of acts of statutes that it's entitled to deal with, Court Matrimonial Causes Act, of course, being top of the list so far as financial remedy practitioners are concerned. But conspicuous by its absence from that list is the Trusts of Land and Appointment of Trustees Act. ToLATA claims can only be issued in the County Court or the High Court. And there was, it seems, a considerable amount of uncertainty about that following the 2013 creation of the Family Court, so much so that the President in 2021 had to issue guidance on the jurisdiction of the family courts. And so if you are left having to argue a point about jurisdiction and you want to make the point simple, you don't have to go through cross references between various statutes. You can just simply go to the simple and direct President's guidance of the 25th of May 2021. And so therefore, if you're bringing a true ToLATA case, then I'm afraid you're issuing in the civil courts. One of the questions we had in advance of today's seminar was, should family lawyers be doing county court actions? Well, no reason why not. Are there ready reckoners? Are there ready guides, says the family practitioner? Well, the answer is come and see counsel. Of course, is the first port of call. But if you're looking for something a little bit ready to hand, I saw on the in the internet, Jack Rendell from Pump Court Chambers has done a very useful analysis that can be found by a simple search. And there is, if you have a subscription to Lexis, there's a very helpful, easy guide to civil procedure in trust of land cases. And of course, there's Rachel's helpful analysis that we had a moment ago. A little bit more complicated are cases where you've got not just a trust of land case, but your client is also intending as a sort of backer, as a belt and braces, to a claim about sharing the distribution of the interest in the family home. There's also an issue she wishes to bring about under the Children Act, which is, of course, Schedule 1 claim. Louise is going to be talking more about that later, but squarely within the jurisdiction of the family court. So you've got one case that's being under the jurisdiction of the county court and one under the High Court. What do you do there? Well, in most cases, you issue in a court centre that has both a family court and a county court. And in those circumstances, the case can be put in front of one of the local district judges who, of course, can manage both together. It's a little bit more complicated where you're issuing in a court centre that doesn't have a family court and a county court. There's a very useful article in the 2023 winter edition of the Family Law Journal, in which Nick Allen, Casey, and others set out the slightly more imaginative ways in which that can be progressed in a court building that doesn't have a family court and a county court. So I would direct your attention to that. What about the other type of case in which the family court is going to have to engage with issues of property ownership? That is in the context of the computation exercise. Well, you get a green light for that. Lord Denning, as long ago as 1981 in Tevitt and Haynes, made it plain that the family court can set about examinations of legal and beneficial interest in properties in order to determine the assets for distribution in a financial remedy case. And you either do that at the preliminary issue stage, TL and ML protocol, or at a later stage. Once the family court has carried out that analysis, then the family court has the power to make a declaration, that specific form of relief. That's because when created, the family court had the power to make any order available to the High Court or the County Court. And amongst those, of course, High Court and County Court powers is making a declaration. And that declaration, the order, will bind any person, husband, wife, intervenor, and says the case of Tevitt and Haynes, anyone who claims an interest in the property in dispute. Now, it's worth bearing in mind that the authorities encourage the family court to take on relatively complex inquiries into ownership of property. This case of Egerton and Egerton Shake is a useful example. Lord Neuberger made it plain that there will, of course, be some cases where the family court judge will direct that a preliminary issue as to ownership of assets involving a third party is heard in another division as a preliminary issue. But, he said, the better course is normally for the family court to determine the issue. Egerton and Shake involved not just family proceedings, but a partnership issue between Mr. Egerton and a colleague of his, Mr. Sheikh, who were engaged in relatively valuable dispute about a partnership, which of course touched on the value of assets available for distribution between the parties. And the court made it absolutely clear that that was the sort of stuff that the family court ought to be engaging in as part of its investigation. That said, just because there is an issue about whether a third party or one of the spouses owns a particular asset, that doesn't necessarily mean that the third party must be joined. It depends on all the circumstances, as the slide tells us from the case of Behbahani and Behbahani. That is a principle we derive from Lord Justice Baker's judgment. What does depends on the circumstances mean? Well, in this particular case, in 2011, there have been the main financial remedy proceedings, in which the wife, needless to say, said the husband was super wealthy, 60 to 100 million pounds, and he owned as part of his basket of assets the Santa Clara Golf Club, hence the thumbnail you see at the bottom of the picture. Husband said, no, I don't. That's owned by a number of companies, which is in turn by a business colleague of mine. And ultimately, Mrs. Justice Parker concluded in those original financial remedy proceedings that the husband did in fact own the golf club, and she ordered a £20 million lump sum. The key was that her order did not invade the particular property ownership of the golf club. It was simply an order that the husband pay £20 million. When enforcement proceedings came about 8 years later, there was an issue about whether Mrs. Justice Parker should have joined the purported owner of the golf club to the action, and the Court of Appeal said no, absolutely not. Whether you join a party depends on the circumstances. You probably do join if one of the parties to the marriage is actively seeking a transfer or sale of the asset in dispute. But in this case, that was not the situation and therefore not appropriate to join. Very simple. How does the court approach the analysis in the family courts? Well, the substantive law is addressed according to as if it was being determined in the Chancery Division. The procedural rules are according to the FPR. So it's a sort of hybrid approach, whether you're looking at substantive or procedural law. What's the procedure for joining? A familiar provision to many of us, the FPR 9.26b. This is, of course, the test that if you're seeking to join, you have to satisfy. It comes in two halves. There's two opportunities. The court may direct that a person or body be added as a party to the proceedings if A, it's desirable to add the new party so that the court can resolve all matters in dispute in the proceedings, or there is an issue involving the new party and an existing party which is connected to the matters in dispute in the proceedings, and it's desirable to add the new party so the court can resolve that issue. You will probably have in your back pocket during the course of those arguments the case of Egerton, the case of Behbahani, to think about the principles that you learn from those. But in addition, there's this desirability test. Is it desirable to join? That applies to whether it's A or B under the provision. And there's a very useful analysis of desirability set out by Mr. Justice Moylan, I think, in one of the lesser known litigation rounds involved in the Immerman divorce. Essentially, says Mr. Justice Moylan, joinder has the advantage of direct disclosure against the parties, cross-examination and enforcement. And then keep an eye on the responsibility as to who applies under FPR 9.26b. The general principle is the person who is applying is the person who is claiming that the beneficial interest is different from the legal title. Once joined, the best practice is set out in TL and ML. It's a series of stages. You join the party as soon as possible. There are then points of claim and dispute. Then you have disclosure and inspection. Then you have witness statements. Then you have list for preliminary issue. Then have FDR. TL and ML, tried by Mr. Justice Mostyn, of course, in 2006, no doubt in the context of a High Court case where people have the time and the available resources to spend on what is a fairly complex and staged approach. And you'll be pleased to know that a year later, Mr. Justice Munby said in A&A that although he was, quote, sympathetic to that approach being suggested by Mostyn in TL and ML, I would not wish to be quite so prescriptive as he appears to be. Vigorous judicial case management in such cases is vital, but the appropriate directions to be given in any particular case must reflect the case managing judge's appraisal of how, given the forensic realities of the particular case, the issues can best be resolved in the most just, effective, and expeditious manner. So, in our more proportionate approach to cases in the family court where there isn't the time and the money to go through the strict TL and ML process, it may be you concertina some of those steps, but it provides the background. And that's how to manage a trust of land type case in the context of a financial remedy investigation. That, I hope, is a fairly effective and expeditious rush through the procedure. Thank you for listening so patiently, and I'm going to hand over now to Louise. As I try
Thank you very much.
Thank you.
Thank you very much, Hamish, and thank you very much, everybody, for bearing with us. You're getting a lot of material here, but I'll just reiterate that you are going to get the slides after this presentation. So I am now moving on to the delight that is Schedule 1 claims. Thank you, that's come up. Thank you. So first of all, we'll look at a Schedule 1 claim, as that won't be familiar to all of you. We'll look at what are the likely outcomes, what are the powers that the court has. We'll then turn to the discretionary factors that must be taken into account, and we'll deal with some of the special features, some things that I particularly wanted to bring to your attention. So what are we talking about? What is a Schedule 1 claim? Well, it's a claim for the financial provision for children. It is a financial remedy within the meaning of FPR 2.3. They remain relatively rare, following on from Rachel's statistics that she gave you earlier. We now have a majority of children being born outside of marriage and civil partnership. There were 605,000 live births in 2022. Of which 51.4% are outside of marriage or civil partnerships. So actually, we should be seeing a lot more of these, yet they are still infrequent. There were 230 applications, so the Ministry of Justice statistics tell us, in 2022. There were only 104 in 2012 by way of comparison. So a little bit of an increase, but still a valuable tool that isn't being utilised as much as one might imagine. So where can you find it? It is Schedule 1 of the Children Act, 1989. At this point, all the strict property lawyers in the room want to leave because they're not going to start to delve into the Children Act. Well, as somebody that does this work, I would say it's nothing to be afraid of. The Schedule 1 itself consists of 17 short paragraphs. There is, as there is often in the Red Book, an essentials guide. That's guide 11, which can be found at page 706. There's also the standard procedural guide at the front of the Red Book, which is at page 8. Two leading cases there for you to look at. Reapy is the leading case. Justice Thorpe sitting in the Court of Appeal. Most important case for you to read if you're going to do work in this area. But another resource to go to is the recent case of Y versus Z. Mr. Justice Peel is now going through a whole varieties of areas of law, setting out these really instructive judgments. And there's a brilliant one for Schedule 1 claims that takes you through all the relevant factors. If you started there and you worked your way through, you'd have almost all the information that you need to get yourself going. So procedurally, it's covered by Part 9 and Practice Direction 9A. There is a fast track procedure set out in 9.9b. That, however, applies when you are only applying for periodical payments. So just take you briefly through the sections. Paragraphs 1 and 2 set out the orders the court can make. Paragraph 3 deals with duration. Important matters set out at paragraph 4. Those are the matters to which the court must have regard. I'll give you a heads up now. I'm afraid not everything is listed in paragraph 4. There are some judicially developed criteria that you'll need to have a look at as well. Paragraph 6, 6A and 7 deal with variation applications. That's often very important in Schedule 1 claims as children grow and develop, and interim orders are permitted. So what orders can be made? We can have periodical payments. Those include secured periodical payments, lump sum payments, settlements of properties. They can take the form, for example, of a trust, a license or a lease, and ultimately there can be a transfer of property either to the applicant or directly to the child. But in reality, what sort of orders are you likely to get? Well, periodical payments. We all know of the ouster of the jurisdiction with regards to child support, but actually you come back through a Schedule 1 if you are in excess of the CMS regime, which is now 156,000 gross. If you get into the category of those sorts of claims, what we're told initially is that we follow the same type of formula. So Mostyn originally had that going up same basis up to around about 650,000. In fact, that's gone beyond now. So we're talking about the people who in the parlance range from the affluent all the way up to the fabulously wealthy. These talks I come on when I do financial remedies works always convinces me that either I'm in the wrong line of work or that I've married the wrong person, because the cases often deal with people who are extremely rich. However, the principles do apply just like they do in matrimonial finance right the way throughout all levels. Housing is often a key feature. We're talking about housing being provided during the minority of a child or through their dependency, because we have extension up to university. Or to the university and continuing an education. Housing also extends to incidental costs. Those can be for the running of the household. We can have a lump sum to meet capital needs, such as a car, an education, private or tertiary education. However, important things to note here, there can only be one property settlement or transfer against the same parent in respect of the same child. So that's very important to bear in mind. Different with regards to periodical payments, different with regards to lump sums, but it's a one time only with regards to property settlements or transfers. All such determinations need to be for the benefit of the child, not for the applicant parent. Well, what does that mean? Sometimes that can be a very difficult dividing line to make. A useful case on that is AZ versus FM that I've set out for you there. That's where Mostyn introduced this idea of a HEXA, a Household Expenditure Child Support Award. That used to be referred to in common parlance as a carer's allowance. So we look at, can provision be provided that extends beyond the direct support of the child to meet the mother's household to the extent that she can't do that herself. It's not always an easy line to draw. Some things are going to be very much on one side of that line. A pension for mother, that's not going to be relevant to the child. The cases include lots of nice examples. A subscription to a nightclub, not suitable for a 3-year-old, but we could have provision of a car, and it could be even as far as provision of designer clothing for mother, depending on the income of the household. So who may apply? The legislation tells us that that could be a parent, a guardian, or a special guardian. It could also be a person named in a child arrangements order of the person the child should live with. There can also be claims by the children themselves where their parents are separated. Generally, the powers under Schedule 1 are more restrictive than the Matrimonial Causes Act, the Matrimonial and Family Proceedings Act, or under the Civil Partnership Act. So it tends to be one of last resort, but can be brought by people who were previously married. ToLATAs and Schedule 1s. Yes, you can absolutely run those together, and that's often a good idea to do so. I've answered one of the questions in the chat about how that might be of benefit, because it allows the court to consider all the resources. So first of all, we look at what is it that the applicant has in their own right. Is there a 50-50 division of the family home? Therefore, under an order of sale, they can recover that 50% interest themselves. We can then go on to look at what resources the defendant or the respondent, depending on which language you're using, has to provide for the child. So you often will see ToLATAs and Schedule 1s run side by side. So I mentioned applications by children. Children over 16 can apply for periodical payments and or lump sums. Children over 18 can apply, so children of the parties can apply. They can apply for periodical payments or lump sums. There are, however, special circumstances. Those are the extended ones where they're in full-time education or training, or certain special circumstances set out in paragraph 2. But note that that is only for periodical payments and lump sums. There are no rights for children over 16 or 18 to apply for transfer or settlement. Who can they apply against? The legal parents, obviously, as long as they are habitually resident in England and Wales. They can also apply for a person who has assumed responsibility for the maintenance of a child. Paragraph 4.2 tells us what we should be looking at, and one of those factors includes whether or not the person knew that the child wasn't theirs. So had they become a child of the family, or was it one of those situations where actually they thought it was their biological child and it transpired not to be? So what are the factors that we look at when dealing with Schedule 1 applications? This is a discretionary matter, not as wide as the MCA discretion, but nevertheless discretion. The key factors are set out in paragraph 4. Some of those are reflective of the section 25 checklist. Not everything is there. So it's important to be double checking. They're in, as I highlighted earlier, a number of also judicially developed criteria. Interestingly, welfare is not listed. Not contained within the relevant factors, but absolutely is, and Repeat tells us this, a constant influence. So rather like a primary consideration, always at the heart of decision making, it always needs to be for the benefit of a child. Standard of living is relevant. You won't see that listed, but it is relevant. It's especially so in big money cases. I've given you a couple of references there. Al Maktoum, people were fabulously wealthy. The ruler of Dubai against the sister of the King of Jordan. So fair amount of money available. More considered, we needed to look at making sure the child didn't have a lifestyle that was entirely out of kilter with the other household. Mostyn, however, reminds us in Colorado Fuchs that the standard of living before is not always determinative. Not all of these applications are going to be made in the context where there has been a loving relationship and the child lived within the family home beforehand. We might have, in the parlance, a child that results from a liaison that was brief. So you might have a very wealthy gentleman who finds that he has impregnated somebody with whom he only had a very passing moment within a restaurant. We all can recall the Boris Becker incident, and standard of living is then relevant. The child could also just be born after the relationship has broken up. So standard of living is relevant. There's a running order to do. We always start out at working out what should be the property provision, then moving on to lump sum, and then moving to child maintenance. The reason we do that, and Repeat is very clear on this, is the starting point is the home. Where is this child going to live? And from that will flow what the capital needs are and the like, what do they need to maintain that? We're told to ignore the fact that this may be a cliff edge. Child may get to 18 or finish tertiary education, and the providing parent may decide that they're not going to make any further provision. That could lead to a dramatic reduction in lifestyle, but different REP this time, tells us to ignore that. The court is also entitled to paint with a broad brush. We're looking at things in the wider spectrum. We don't need to be going through budgets for each year with a fine tooth comb. And a heads up for you, as I mentioned, not all the Section 25 criteria are contained. Conduct has very limited relevance within Schedule 1 applications. It does crop up sometimes. There's a case, for example, that was recently determined by Nick Allen, TK versus LK, where, for example, the mother had committed a criminal offence against the child, was serving a long custodial sentence, and the court considered that to be relevant conduct. Public policy is relevant. We should be aiming to reduce or eliminate support from public funds. Just because the state would provide, it is not a sufficient reason for the other parent not to provide. And ultimately, the outcome that we're looking for is fair, just and reasonable, taking into account all the circumstances. So that's a highlight there of some of the judicially developed criteria. We then look out at what is expressly set out in paragraph 4. The income, earning capacity, property and other financial resources in the foreseeable future of the parent or of the applicant. That'll be familiar to family practitioners under the Matrimonial Causes Act. That's highly relevant. What's the pot? What's available? We do, however, in Schedule 1 claims, have a millionaire's defence. It doesn't get you off the hook completely, but what you don't need to do is go through in a fine-tooth comb all of the assets. So you can avoid the detailed disclosure as long as you provide sufficient evidence. So a wealthy man may be able to say, this is a broad indication of my wealth, what is available. We don't need to know exactly what the King of Jordan has down to the pounds, shillings and pence. It's enough that he could meet any award that the court may make. We know that an applicant of limited means is not required to use their own resources. So F and G, mother had an income of only £13,000. She could keep for herself. She didn't need to apply it towards the child. So we look at the financial needs and obligations and responsibilities of the adult parties. We also look at the financial needs of the child. So that's where you will be expecting a schedule or a list, rather like under the Matrimonial Causes Act. Sometimes those can be a bit of a wish list. We look at the income, earning capacity and property and other financial resources in the foreseeable future for a child. In big money cases, they might be a beneficiary under a trust or a settlement. An important relevant factor is the physical or mental disability of a child. They may need additional provision. And the manner in which the child was being or is expected to be educated. So, for example, was private school at what level was anticipated? So a couple of special features, some things to look out for. If a child turns 18 during proceedings, an order can still be made. This isn't, for example, like the Court of Protection, where when a protected party dies, the proceedings come immediately to an end, or indeed some of the issues that arise in divorce upon death. A child turns 18, the order can still be made as long as the application was valid at the time. You can get variations for children who are over 18, as long as the extension conditions, you recall me mentioning about being in full-time education, are satisfied, so it can carry on longer. And just a warning to you, we're not dealing with sharing or compensation in these cases. It is a needs-only jurisdiction. I'm just going to carry on for a few short moments just to romp you through the remaining bits. Ideally, the norm would be provision of housing by way of settlement of property rather than a transfer. Transfers outright should be limited to, for example, public sector housing where we're transferring tenancies, or those special or exceptional circumstances. For example, the TK and LK case that I referred you to earlier. And settlement should be the norm rather than allowing rent under a maintenance order. But if that's the way the resources need to be provided, the court has and does regularly provide that. Finally, just turning to costs. Legal fees. Legal fees could be ordered. So provision for a fighting fund by way of interim PPs. You'll recall I said that we could have interim orders here. That's a way to do it. You can have provision of a cost fund. There was a dispute in previous years as to whether or not that was possible, but MT versus T made clear that that could be held to be for the benefit of the child. The parent is bringing it effectively in a quasi-representative capacity, and therefore it is for the benefit of the child. However, I'd just ask you to note that Section 22ZA doesn't apply. Don't get caught into the trick of making reference to a LASPO. We aren't under 22ZA, we are instead under the common law. But Mostyn comes in to save the day once again. What he tells us under Rubin and Rubin is that we apply the 22ZA principles with the necessary modifications. The 22ZA, he says, was effectively a codification of the common law principles that derive, for example, from Curry and Curry, and that's the framework that we use, but what you mustn't do is call it a LASPO. So some details about me, and then an invitation for you with regards to questions and answers. Thank you all so much for the questions that you sent in advance. We've included those within our subject material as much as we possibly can. I've been busy typing, Rachel has as well. I don't know if Hamish has, because I've been busy talking to you. So we have been covering some of the material, and we're going to take some questions from you now. We're going to go in the same running order that we did earlier. So I'm going to turn to Rachel, who's got a question that she's going to answer for us. Thank you, Rachel.
Thanks, Louise. Yeah, plenty of questions coming in. I've been furiously typing away. Hopefully you've got some responses there. And to reiterate, you will get a copy of the presentation slides, so there is plenty of information for everyone there. One question that I received previously was regarding survivorship and severance when it comes to ToLATA claims. So is there a way of avoiding the risk of survivorship rule whilst there is a dispute as to the beneficial ownership of joint tenants? My understanding is that if a joint tenancy is severed, the couple will be joint tenants in equity, which may be undesirable. So just to kind of reiterate severance, because it is quite a useful point. Just because the parties have agreed to be joint tenants doesn't mean that they have to remain that way. They can either both parties or just one single party can serve a notice to sever the tenancy, which basically means turning them from joint tenants to tenants in common. Normally there would be equal shares 50-50. Of course, the parties could agree to sever the joint tenancy into unequal shares as well, which would, I suppose, be akin to an express trust as well. Why would you ever want to sever a joint tenancy? Well, firstly, it ends the automatic right of survivorship. So your share does not automatically pass over to the next person. And that's probably quite important when you're breaking down a relationship. Often as well, if the property is receiving rental income, you may want to receive that in an unequal share. So it's quite useful to sever the tenancy and receive that in the shares that you agree. So just to set out severing a joint tenancy, you complete it. Ideally, you would put it in writing, in a prescribed writing, and complete what's known as a form SEV, which will be sent to the land registry, which will then register that onto your property title, so it's very clear that it's been severed. So that's the reasons why you might want to sever a joint tenancy, and it is often quite useful, I would say, in ToLATA cases, especially when the trust is broken down between the parties. Just a reiteration, because I've had a couple of questions on this. When I mentioned the pre-action protocol, there is not a specific one for ToLATA cases. It's just a general pre-action protocol that applies to civil procedural claims that can be used. So just to clarify on that, I've also been asked to reiterate what the case that I mentioned, which was I think it's Thomas and Seinberg, Cynberg, really important High Court case that came out this year. In terms of any other questions that I can answer, I might pass over now because I think I've answered most of them off the chat.
Thank you so much, Rachel. I'm delighted to say I think I really only had one question that arose specifically out of my talk, which means either everyone was listening very carefully or they weren't listening at all. The question was this: how do you run a trusts of land action and a Schedule 1 Children Act claim together? I gave some commentary to this during the talk. The answer is you issue in a courthouse that has both a family court and a county court centre. And I recommended that if you want a little bit more narrative about that very issue, then in the 2023 winter edition of the Family Law Journal, there's an extremely useful article prepared by Nick Allen and others, which deals with that very question, as well as the more knotty question about issuing in a court building that doesn't have a county court and a high court in it, and in particular in the CFC. And in relation to the CFC, it's a sort of old shadow of the former construction of the family court that the family division still has, of course, its principal registry of the family division, which is essentially a high court organ. It's a high court organization. And within the PIFD in the CFC, there are a number of deputy district and district judges who therefore sit as district judges of the High Court. We know that ToLATA cases can be dealt with, of course, by the High Court, and therefore, if you're dealing with the CFC, you put it into the CFC and ask it to be sent straight to the deputy or district judges who sit in the principal registry of the family division. It all sounds slightly Byzantine, and I warned that it would be, but it's set out in nice, easy terms in the Financial Remedies Journal in their Winter 2023 edition. Now, I didn't want to body swerve my obligation to take a number of questions, so I just thought I'd pick up on a couple which I've seen, which probably fall into other people's talks, but if mainly into Rachel's actually. So since Rachel's gone on questions, I'll sweep up a few of these. One of the questions that we got in advance of the seminar was, is it possible for a mother who only has contact with the children to regain her 50% equity from a family home while the children are still under 18 and continuing to live there? And of course, the answer to that question is yes, it is possible. In principle, that's entirely possible. It all depends on what the parties' resources are. And the court in the first instance will be asking, well, if we're leaving, and I'm assuming it's the father here who has principal obligation for the children living with him. The question is, does the father have the financial resources to be able to buy out the mother's share, in which case they can continue to live in the house, and the mother is then able, hopefully, to apply her lump sum to her own housing. Of course, if that's not possible, the court may look at selling the property, but ensuring that the father and the children can move on to an appropriate property which can house them, and thereby civilly release the mother from the trust and get her cash out. Another question was, would Jones and Kernot be the way if the TR1 was signed 50-50 tenants in common, but one of the parties was simply on the mortgage and the title to enable borrowing and didn't actually contribute to the deposit? This is, if I may say, a common issue which arises particularly with family lawyers about the common course of dealing between the parties point. There was a very helpful authority, Pankania and Chandegra. It's on Judge Harris, who unfortunately was put straight by the Court of Appeal. The reality is that the TR1 is the defining document. If it's signed and it says 50-50 tenants in common, that pretty much is the end of the story. And just quoting from the judgment of Lord Justice Patten in the case, he said, in the absence of a vitiating factor like fraud or mistake as a ground for setting aside that express trust or a ground for rectifying it, the court must give legal effect to the express trust declared in the transfer. In the absence of such claims, the court can't go behind the trust. Next question. Can ToLATA proceedings be used to claw back funds on a property jointly owned but sold 3 years ago? Answer, yes. Can you establish a trust where the co-owners have never lived with each other? Yes. And the final question is where co-owners owned the property and then one of them spent a considerable amount of money investing in the property after they bought it. What happens there? There is a line of authorities which flows from Stack and Dowden on this. Yes, you can. Of course, the parties can agree as time has gone on to change the nature of the trust. A beautiful term used by Lord Neuberger, an ambulatory trust, meaning you sort of walk round the trust and it changes as you walk, as these events as these events change. So if the parties agree to change the trust after purchase, then yes, indeed, the trust can change in the nature of the distribution between the parties. Yes, well, we're already past 1/4 past. Louise, have you got any you want to sweep on? You were fantastically busy on the social media platform replying in writing. Is there anything you want to speak to on the on screen before we conclude the seminar?
I'll just do a quick couple, Hamish, but I'll just
Yeah.
draw to your attention. There's been a couple of people just asking you to repeat some of the things you just said in your answers. Was it the Jack Reynolds guide that you were referring to?
Yes, yes, it was.
Thank you.
That's
Thank you
right.
very
Yeah,
much. So we
yeah.
had a query about that.
Thank
And
you.
somebody else wanted to know that there was a case you just referenced. I think you brought up two names. If you can remember either of those and say them more slowly, I'm sure the participants would be grateful, but I'm afraid I was multitasking at the time.
Oh, was that in my last answer?
In your last answer.
Yes, yes, and certainly. If I understand the question right, this is the case of Pancania and Chandegra. It's 2012, EWCA, Civ 1438.
Thank you, Hamish. That's terrific. I'll just
Thank
pick
you,
up
Louise.
on two quick points. We've had a question asking if you can bring a Schedule 1 claim for a lump sum after the conclusion of financial remedy proceedings for divorce. The answer is that yes, you can. It's going to be in reasonably unusual circumstances, often a considerable amount of time afterwards, so things have changed. So imagine a scenario, indeed this is what cropped up in TK and LK, where one of the parties then received an inheritance. That lady was in prison, and yet she received an inheritance. 350 was the total estate divided with her brother, so she then had 175 available, and the court said that father could come back and have an application with regards to that. The final question I was just going to touch upon is the mortgage capacity of the respondent ever relevant in a Schedule 1 claim? Yes, it is, because it's the resources that he has available to him. So if he lives in a property outright, but has an untapped mortgage capacity, that could be available for him to provide sums, either secured against his own property, thereby releasing capital to the others, or by purchasing a property that he then purchases under mortgage and then rents out to the caring parent. Just wanted to pick up from that question further. The question was asking about the relevance of the 156 threshold. The 156 threshold for CMS is relevant with regards to child maintenance. It regards to periodical payments. So even if somebody earns considerably less than that, if they are asset rich, you can still have a Schedule 1 claim that is brought against them. So as we are now past our period of time, I will stop there and I'll just hand over to Hamish to say the thank yous and goodbyes.
Yes, well, here come the thank yous. I want to thank of course, my two fellow panelists, who I recognise have done a great deal more by way of heavy lifting in the two seminars they gave than I did in mine. So thank you so much for such a comprehensive analysis of actually many aspects of the wide-ranging ToLATA regime, such that we saw it, involvement in Matrimonial Causes Act and in Schedule 1 cases as well. Thank you so much to all of our many registrants who signed up and turned up this afternoon. You've given up your busy Christmas period. I hope you felt you got a touch of the Christmas pantomime with the interactive features of the seminar. But many thanks for your participation and engagement. And it leaves me just to say that to keep you hooked, the next instalment from 3PB is certainly the family group. We do a family group brunch, many of you may know, online Teams seminar. The next one is on Thursday, the 30th of January, 2025. It's a closely kept secret as to what the title is going to be, but please keep your eyes peeled for the announcement as to both topic and speakers. Many thanks finally to Delphine Avondo, who you can see is on our screen. She's carefully managed us three. Many thanks to her. And I'm sure from us at 3PB, we wish you all the very best for Christmas. And thank you very much for joining us. Bye-bye.